fellow world. This is Attorney Angel and I'm your legal angel. Hi my fellow angels! It's been quite some time since my last vlog. I've been very busy with so many things. I miss all of you. I hope you miss me too. Now I'm sharing with you a recorded lecture that I use for my Statcon class. I think it's more than a year already, but I thought I could share it with you so you can also learn a thing or two from that lecture. So, of course, before anything else, thank you very much. We're now more than 920 plus subscribers. Thank you very much, especially to my silent supporters and subscribers, okay? My organic subscribers as well. I'm very, very grateful. I hope you help me spread the word, share the word, like, subscribe, share, and follow so we can spread more positivity, and also we can make our kababayans all over the world, not just aspiring lawyers and law students, about the law, okay, the cases, etc. Marami pang iba na pwedeng matutunan. And of course, on the sideline, the other L's for my vlog, living and loving as well, aside from the law and learning. Alright, here it is. I hope you learned something from this. To continue with our discussion on statutes and the legislative making process. Note that the power to make laws is essentially lodged in the legislative department of the government or the legislature, and this is provided for explicitly in the 1987 Philippine Constitution. Now, the power to make laws also include the power to alter or repeal laws. And this is again provided for in Article 6 of the 1987 Philippine Constitution, and this is our legal basis. Now, the legislative making body or the legislature undergoes the legislative making process, or in other words, how a bill becomes a law, from the time that a bill is filed and proposed until it becomes a statute or enacted into law. There are certain terms and definitions that we have to remember, such as bill, draft, act, and statute. Let's go first to bill. A bill is a draft of the proposed law from the time of its introduction until it goes through all the different stages in the legislative making process in both houses of Congress, both the Senate and the House of Representatives. Now, when we say draft, draft refers to the form of a proposed law before it is enacted into law by a vote of the legislature. And when we say act, this is the appropriate term because it means that it has been acted upon or acted on by the legislative making body or the legislature. Then it becomes the statute. And of course, the statute is the law itself, the enacted law, which is a reflection of the written will of the legislative making body or the legislature, conforming to the different requirements and the forms provided for by law to constitute as a law. There is also a term we know as statute law. This is sometimes used interchangeably with the word statute, but experts say that it has a broader meaning in that it includes judicial interpretations of the enactment itself. Now, there is also a term in which is called the compromise bill. So if you study the legislative making process or the process of how a bill becomes a law, which is also part of your assignment, and I hope all of you can draw your own diagram to illustrate the process of how a bill becomes a law. There is what we call as a compromise bill, and This is when there are variances or differences in the bills proposed in the House of Representatives and the Senate. And this is the one which passes through the BICAM or the Bicameral Conference Committee, wherein amendments can be introduced to both versions to harmonize the versions coming from the House of Representatives and the Senate. Now, always remember that there are constitutional limitations in the passage of the bills. Okay? First, that there should be no ex post facto law or bill of attainder, and that there are also three important requirements that have to be complied with, and these are provided for in Article 6, Section 26, and Paragraph 1, Paragraph 2. And for the first one, we have under Article 6, Section 26, Paragraph 1, the Philippine Constitution states that every bill passed by Congress shall embrace only one subject which shall be expressed in the title thereof. In other words, one subject, one title one subject in one title policy. Okay, and the purposes of this constitutional requirement are to prevent hodgepodge legislation or log rolling legislation, and also to prevent surprise or fraud upon the legislature. And last but not the least is to fairly apprise the people through such publications of legislative proceedings as is usually made of the subjects of legislation that are being considered, in order that they may have the opportunity of being heard thereon by petition or otherwise, if they shall so desire. Okay. Now, in the case of Alalayan versus National Power Corporation, 24 SCRA 172, 1968 decision, the Supreme Court stated that this provision is similar to those found in many American state constitutions. It is aimed against the evils of the so-called omnibus bills and log rolling legislation, as well as surreptitious or unconsidered enactments. Where the subject of a bill is limited to a particular matter, the lawmakers, along with the people, should be informed of the subject of proposed legislative measures. This constitutional provision thus precludes the insertion of riders in legislation, a rider being a provision not germane to the subject matter of the bill. So take note of that term, rider, and its definition. Now, under Article 6, Section 26, Paragraph 2, we have another requirement under the Constitution which provides for the requirement on 3 readings on separate days and the distribution of the printed copies in final form before the passage of the bill. So it states that no bill passed by either house shall become a law unless it has passed 3 readings on separate days and printed copies thereof in its final form have been distributed to each member 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency upon the last reading of a bill. No amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. Alright. Moving on to the third requirement under the Constitution, which is that every bill passed by Congress shall, before it becomes a law, be presented to the President. Now, there are three paths or routes for the last stage on the bill becoming a law. It can either be through the signing by the President, which is in effect his approval, or the President can veto and it will go back to the Congress, but it can be overridden by two-thirds of the votes of the members of the House of Representatives and two-thirds of the votes of the Senate. Or the President may um, have may leave it with no action, or if there is inaction for a period of 30 days, the said bill will lapse into law. Okay? So every bill passed by the Congress shall, before it becomes a law, be presented to the President. So if he approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. Then, if after such reconsideration two-thirds of all the members of such House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by two-thirds of all the members of that House, it shall become a law. In such cases, the votes of each House shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. All right. The executive approval and veto power of the President is the third most important constitutional requirement in the mechanical passage of the bill. Remember that. And this is a mandatory requirement. And this is also considered as part of the principle on checks and balances, which is also one of the principles in connection with the branches of government and concomitant to that of the principle of separation of powers. At the beginning of this recording, I already stated that as part of your assignment, you will have to study the legislative making process and that you have to draw your own diagram to illustrate the said process. Now, just to emphasize on the part of the legislative process with respect to the three readings, for the first reading, remember that this is the part where the reading of the title and the number are done, and that the principal author may propose or accept additional authors as well during this part of the reading. And after which, this will be referred to the appropriate standing committee. Okay? And this is thereafter included in the committee report, and it is calendared for business. Now, for the second reading, during this stage, sponsorship speeches are held, and this is also the period of debate and the period of amendments. After all these, there will be approval, and there will be an engrossing of the bill. After which, there will be distribution of copies of the bill before the third reading, and it must be at least 3 days before the reading. At the third reading, this is the stage where the approval is made and no more amendments will be allowed. And this will then start the ball rolling because it will then pass the bill after the third reading to the other house. Before we proceed to the discussion on statutes per se, please take note of the definitions of engrossed bill, enrolled bill, and the enrolled bill doctrine. So when we say engrossed bill, this is the final form or draft of the bill, which is prepared for distribution. And when we say enrolled bill, this is the bill which has passed through both houses in the legislative making process. And when we say enrolled bill doctrine, this is the principle that The court assumes or presumes that when a bill becomes a law, it has passed through the proper processes of the legislation or the legislative making body until it is signed into law. Now, for statutes, part of your assignment is to choose your own statute and label them with the different parts. So just to have a run through of the different parts of the statute, of course, we have the official citation, which includes the nomenclature or the name by which the statute is designated, and now we have Republic Acts. And part of the official citation, we have the number, which is the nominal number, the cardinal number, the ordinal number. And of course, after which we have the title, the long title. We have the part of the statute explaining the reasons for its enactment, which can be found in whereas clauses. Now we have the declaration of state policy and the explanatory note. And then we also have the enacting clause, the part of the statute which declares its enactment and provides the force of law. And you will see there, be it enacted, and so forth and so on. Of course, we have the body of the statute, which is composed of several paragraphs and several sections or subsections. In each section, you have the epigraph. And we have different kinds of clauses, such as the repealing clause, the saving clause, separability clause. Some also provide the interpretative clause. And last but not the least, of course, the effectivity clause, which is that last part of the statute announcing the effective date of the law. All right. Now, for the kinds of statutes, we have already discussed some of them at the beginning of our classes. But just to mention some of the statutes which we have not discussed, we have general law, and it refers to the law or statute that affects the community at large. This is different from public law, which is a general classification of law consisting of constitutional law, administrative law, international law, and criminal law. And we also have special law, which refers to the law which is considered special when it is different from others of the same general kind or designed for a particular purpose or limited in range or confined to a prescribed field of action on or operation. Now we also have local laws. These are laws which relate or operate over a particular jurisdiction or locality instead of over the whole territory of the state. We already discussed about private law and also adjective or procedural law. We have also what we call as curative statutes, which is a form of retrospective legislation which reaches back into the past to operate upon past events, acts, or transactions in order to correct errors and irregularities and to render valid and effective many attempted acts which would otherwise be ineffective for the purpose intended. We also have penal statutes, which defines criminal offenses and specify corresponding fines and punishment. We have prospective laws, which are applicable only to cases arising after their enactment. Retrospective laws, or those which look backward or contemplate the past. We also have affirmative statutes which are couched in affirmative or mandatory terms. One which directs the doing of an act or declares what shall be done, in contrast to a negative statute, which is one that prohibits a thing from being done or declares what shall not be done. We have mandatory statutes as well, which is the generic term describing statutes which require and not merely permit a course of action. They are characterized by such directives as shall and not may. So we use the word shall instead of using the word may. Still on the discussion of statutes, we have the concept of vague statutes. Um, this exists when it lacks comprehensible standards that men of common intelligence must necessarily guess at its meaning and differ as to its application. Vague statutes are repugnant to the Constitution for two main reasons. One is that it violates due process because it fails to give fair notice to the people of the conduct which to avoid. And the other reason is that it leaves unbridled and arbitrary discretion to the law enforcers in the enforcement of the provisions. Now, in the case of Sandigan Bayan versus Estrada, the court held with respect to the constitutionality of 7080, or an act defining and penalizing the crime of plunder, the Supreme Court upheld the constitutionality of the said law and stated that the test in determining whether a criminal statute is void for uncertainty is whether the language conveys a sufficiently definite warning as to the prescribed conduct when measured by common understanding and practice. It must be stressed, however, that the vagueness doctrine merely requires a reasonable degree of certainty for the statute to be upheld, not absolute precision or mathematical exactitude, as petitioner seems to suggest. Flexibility rather than meticulous specificity is permissible as long as the metes and bounds of the statute are clearly delineated. An act will not be held invalid merely because it might have been more explicit in its wordings or detailed in its provisions, especially where, because of the nature of the act, it would be impossible to provide all the details in advance as in all other statutes. Now, with respect to the powers of the President as the chief executive of the land, the President has the power to issue orders, rules, and regulations. In Chapter 2, Book 3 of the Revised Administrative Code of 1987, you can find an enumeration of the orders, rules, and regulations that the President can issue, including executive orders or EOs, administrative orders, AOs, proclamations, memorandum orders, MOs, memorandum circulars, MCs, and general or special orders. Now, executive orders are acts of the President providing for rules of a general or permanent character in the implementation or execution of constitutional or statutory powers. And example, EO 68 series of 2012, the EO establishing the VAT tax credit certificates or VAT TCCs monetization program. Now, for administrative orders, these are acts of the President which relate to particular aspects of governmental operations in pursuance of his duties as administrative head. And an example would be AO number 39 series of 2013, which mandates government agencies to migrate to the government web hosting service or GWHS of the Department of Science and Technology, Information and Communications Technology, DOSTICTO office. Proclamations are acts of the President fixing a date or declaring a status or condition of public moment or interest upon the existence of which the operation of a specific law or regulation is made to depend. Example, Presidential Proclamation 655 series of 2013 declaring the regular holidays and special non-working days and the special holidays for 2014. Next, memorandum orders are acts of the President on matters of administrative detail or of subordinate or temporary interest which only concern a particular officer or office of the government. An example would be Memorandum Order number 66 series of 2014, which created the Metro Manila Skyway Stage 3 Project Coordinating Committee. Next, memorandum circulars are acts of the President on matters relating to international administration which the President desires to bring to the attention of all or some of the departments, agencies, bureaus, or offices of the government for information or compliance. Example is Memorandum Circular number 60, series of 2013, which enjoined all heads of the departments, agencies, and instrumentalities of the government to send nominees to the National Government Career Executive Service Development Program, Public Management Development Program. And special orders and general orders. These are acts and commands of the President in his capacity as Commander-in-Chief of the Armed Forces of the Philippines. Like for example, General Order number 11, series of 2009, which directed the Armed Forces of the Philippines and the PNP to prevent and suppress lawless violence and acts of rebellion in the province of Maguindanao. We now go to the ordinance. First, let us discuss the local government units. By virtue of the Local Government Code of 1991 or Republic Act 7160, otherwise known as the Local Government Code of 1991, the local government units were created, and along with the LGUs are the creation of its local legislative bodies, including the Sangguniang Barangay for the barangay, the Sangguniang Bayan for the municipality, the Sangguniang Panglungsod for the city, and the Sangguniang Panlalawigan for the province. Even for the SK, we have the Sangguniang Kabataan Council. And all these local legislative bodies, these have the authority to approve ordinances and pass resolutions geared towards effective and efficient local governance. Now, for an ordinance to be considered valid, it must pass the tests of a valid ordinance, or it must conform to the substantive requirements provided under the law. Now, in the City of Manila case, or White Light Corporation versus City of Manila, involving the ordinance of the City of Manila on wash-up rates in inns and motels, the tests of a valid ordinance were laid down. These tests or substantive requirements are also discussed in a long line of cases involving the validity of ordinances. Okay, and we have 6 requirements as provided therein, and the reading assignment involves the case of the White Light Corporation versus City of Manila. That I trust that you will read, you will study, and it is included in the Case Digest compilation as well. Now, it must conform to the following requirements. Number 1, it must not contravene the Constitution or any statute. Number 2, it must not be unfair or oppressive. Number 3, it must not be partial or discriminatory. Number 4, it must not prohibit, but it may regulate trade. 5, it must be general and consistent with public policy. And 6, it must not be unreasonable. So if there is conflict between a statute and an ordinance, the ordinance must give way to the statute. In the same way that the ordinance must be in line with the Constitution. Okay, the Constitution having the supremacy from all other kinds of laws. And the reason why the ordinance should bow down to the statutes or should not contravene the statute is because These local councils or local legislative bodies, they exercise only delegated legislative power, which was conferred by Congress by way of the law. Or as we know, the Congress is the national lawmaking body. And of course, the delegate cannot be superior to the principal, or it cannot exercise powers more than that of the principal. The principal being the Congress, and the local council being the delegates. So the local government units cannot undo the acts of Congress from which they have derived their powers in the first place, and they cannot negate this by mere ordinance. Um, they cannot negate the mandate of the statute by just the ordinance. And of course, always remember the supremacy of the Constitution over all types of laws. As regards the courts, of course, the Supreme Court and such other lower courts as may be established by law possess judicial power. And such lower courts that we have under the present law on the reorganization of the judiciary, we have at the top of the hierarchy of courts the Supreme Court. Then we have the appellate courts, the Court of Appeals, the Court of Tax Appeals, and Sandigan Bayan. Then at the second level courts, we have the regional trial courts, including Sharia district courts. And at the first level courts, we have the metropolitan trial courts, the metropolitan circuit trial courts, the municipal trial courts, and the Sharia trial courts. All right. When we say judicial power, this is the duty of the courts to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part or of any branch or instrumentality of the government. This is the traditional concept of judicial power. Of course, we know that in the separation of powers, the court interprets the law, while the executive executes or implements the law, and the legislature or legislative making body, or legislature or legislative making body, the Congress, both houses, are involved in making the law. Now, in addition to this judicial power of the Supreme Court, the court also has the power of judicial review, or the power to declare a treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, including ordinance, regulation, and others unconstitutional. This power also includes the duty to rule on the constitutionality of the application or operation of PDs, proclamations, orders, instructions, ordinances, and other regulations. There is also, going back to the power of the judiciary or the courts to interpret the law, as part of the discussion during our first or second meeting on the sources of law, we discussed about Article 8 of the New Civil Code of the Philippines, which made it clear that application of the law is not the same with interpretation. Okay? But under Article 8, we said that part of the source are court decisions, and the legal basis is Article 8, which states that judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. So, take note of the word or, the conjunction or, between the words applying and interpreting the law. Okay? Now, there is also another important term that you have to remember, which is a prohibition on the part of the exercise of judicial power of the courts, which is judicial legislation. When you say judicial legislation, This is prohibited because the court cannot read into the law something that is contrary to its express provision, and cannot justify this as correcting a perceived inadvertence. The court has no power to add a clearly omitted and excluded person, thing, or object by mere judicial construction. And if the court, in the guise of exercising its power to construe or interpret, fills in the gaps in the law that cannot be justified by the spirit of the law or by the doctrine of necessary implication, it is already legislating. That is judicial legislation. And that is prohibited because the power of legislation belongs to the legislature. That is the end of our discussion for today. That's it for this vlog. Thank you very much. Be kind, be a blessing to others, and always remember to glorify God with a grateful heart. This is Attorney Angel, and I'm your legal angel. Borahe, saranghe.